Regina and Dale, a Court of Appeal decision. This particular defendant didn't plead guilty at the magistrate's court stage. He wasn't committed for sentence to the Crown Court. Rather, he put off his pleas and was sent to the Crown Court. And one of the reasons he put off his pleas was that, and I feel for the solicitor dealing with the case in the magistrate's court, the basis of plea wasn't agreeable or couldn't really be agreed with the lawyer in the magistrate's court. And so the solicitor thought, well, we're going to have to sort this all out at the Crown Court then, aren't we? The client was sent. The basis of plea wasn't even agreeable at the Crown Court, and there was talk of a Newton hearing, which didn't happen. Obviously, he pleaded guilty at the listing at the Crown Court. Judge said, you're not entitled to your third. I'll give you 25%. That was the appeal. Court of Appeal agreed. Credit of 1/3. Not available in these circumstances. One of my all-time favourite reads, Placu, Borden and Smith. Go on, Clive, tell us about this one.
Well, this follows on, doesn't it, from the case of Hodgin as well. And there's very much it's very clear. The Court of Appeal are very clear about appropriate credit for a guilty plea. And these are your either way offences. The summary onlys are easy because they're staying in the magistrate's court and you need to plead at the first available opportunity. The indictable onlys are relatively easy too because they're being sent to the Crown Court. But of course, if you want full credit, you need to indicate your plea in the magistrate's court. Of course, you can't enter a guilty plea in the magistrate's court to an indictable only offence. So it's these in-between cases, it's the either way offences. And Hodgin was one of my favourites, Colin. I always remember Hodgin. Mr. Hodgin was hedging his bets. That's how I always remember the name of that case, when his advocate put on the form in the magistrate's court, likely to plead guilty in the Crown Court. And the Crown Court judge was having none of it. He said, that means nothing and is well known to mean nothing. And then on the back of that, of course, we had Placu and others as well, where the Court of Appeal said ostensibly the same, that where there is an either way or indeed a summary only, then an unequivocal plea of guilty must be entered at the first available opportunity.